Ohio versus Ruth R. Miller. It's case number 2025 CR 090285. And we are here today as the court had previously scheduled this hearing for the purpose, really the limited purpose of addressing a jury instructions in this matter, and more specifically, the jury instruction pertaining to the issue of wrongfulness. And in this matter, Ruth Miller is present. She is seated at counsel table along with two of her attorneys in this matter, Lucas Trott and Madeline Grant, both seated at counsel table with her. State of Ohio is represented in this matter by the County Prosecutor Ryan Steyer and Assistant Prosecuting Attorney Fred Scott are all present for this hearing. And Ms. Miller, at this hearing, I'm mainly going to be listening. I'm going to be listening to what the attorneys have to say. They have already submitted to me, and I have reviewed, one, the initial request that had been made by the state pertaining to that jury instruction. An objection was filed by your attorneys, and that is dated December the 29th of 2025. I reviewed that as well, and then just today I was handed a copy of the reply filed by the state of Ohio as well. I've considered all of these items before we came in. Done even some additional research on my own. But I can tell you today, Ms. Miller, I'm not going to rule from the bench. I'm going to listen. And I'm not going to listen, I'm not going to have anybody submit more things to me in writing, but I'm going to go back and look at what they submitted again, because I know it's important to everyone involved. But I just wanted you to know, going in, that's what's going to happen. There's going to be a lot of talk by the attorneys, a lot of listening by me, and then I'll issue my decision in writing. I'm going to start in this case with the state of Ohio, and they're going to have the opportunity to be heard first. I'm going to allow one of your attorneys to respond on your behalf, and then if there's any rebuttal that needs to be made, I'm going to hear from the state on that issue as well. Before we go any further, though, I'm just going to ask the attorneys if there is anything beyond what I have put on the record here at the outset that they feel should be addressed as well today. And I'll start first with the state. Beyond what I have said, Ryan, is there anything else?
No, Your Honor.
Okay. And Madeline, anything on behalf of Ms. Miller?
No, Your Honor, thank you.
Okay. I just wanted to confirm that, Ruth, to make sure that we're all on the same page as to how we're going to proceed today. As we are, I'm going to hear from the state of Ohio. Ryan.
Thank you, Your Honor. I want to keep my initial remarks, relatively brief, because we have had the opportunity to brief this, and I appreciate that opportunity. And I believe at this point it's been thoroughly briefed. And, Your Honor, I think that what we can say is that we agree on a lot of things at this point. Having read the objection of the defendant, and three things we agree on. We agree that the term wrongfulness as used in the revised code does not fully contemplate the law as it relates to wrongfulness. Namely, that wrongfulness is broken into three categories in the literature and as taught in law schools. It's not exactly the rubric of case law, but it makes sense of the case law. And those three categories are legal wrongfulness, objective moral wrongfulness, and subjective moral wrongfulness. We further agree that subjective moral wrongfulness is not the standard in Ohio law. And the jury, the state's position needs to be made aware of that, and the forensic examiners need to know that is the ruling of the court as they do their work. And then last, and most significantly, we agree that the state's proposed jury instruction is a correct statement of Ohio law. Now, we could stop right there, and that would justify the court ordering that jury instruction forthwith. And I would urge the court to do that soon for the reason that the forensic examiners are doing their work at this point. The state examiner has already done his work. We have an independent examiner who has begun his work and will be interviewing Ruth this week. And I understand that the defense forensic examiner has already interviewed Ruth and is in the process of doing her work as well. Now, the defense argues that despite the fact that the proposed instruction is a correct statement of law, that it would be misleading to the jury. I strongly disagree. It's my experience that when juries are given clear and correct and accurate legal instructions, that is beneficial to those jurors. And to suggest that the juror would be misled by a clear, accurate statement of the law is really demeaning to the jury. Now, I would go further, and I would say to not give this instruction to the jury would be misleading to the jury. Because we agree that the term wrongfulness can be broken into 3 categories, only 2 of which are applicable in this case. If the jury doesn't know that, they are being misled. And furthermore, what a forensic examiner does is that they assess the facts, the objective facts in the evidence, the facts gleaned from interviewing the defendant, and they apply that to the law. And so the forensic examiner also needs instruction on that law so that they can follow the precise instruction of the law. Now, one court of appeals in our state has limited that instruction to legal wrongfulness only. Most courts include subjective moral wrongfulness, and that is what the state is requesting here. So the forensic examiners need to know that because that's a predicate of the work they're doing. Their conclusion flows from their application of the facts to the law of insanity in Ohio. And so with that said, Your Honor, I think that we have shown that the instruction is warranted, that it is accurate. We agreed that it is a correct statement of law. And my request is that this court make a ruling on that sooner rather than later. And ideally before the forensic examiners would author their reports, which really should be done by the end of this month.
Okay. Madam, on behalf of Ms. Miller, whoever was going to speak.
Thank you, Your Honor. I'd also like to keep our remarks somewhat brief and lean primarily on the filings. I agree with the state of Ohio. There is a lot which we agree on, specifically sort of the general propositions about what the Ohio Revised Code and the case law says about the definition of sanity. Now, there is one, I think, very foundational area on which we do disagree at this juncture, and that's whether or not simply whether a jury instruction is legally accurate is the end of that analysis as to whether or not the jury actually hears it. I would submit that that's not at all the case. There must be, a factual nexus between that instruction and the facts of the case. Your Honor, at this juncture, we would submit that that factual nexus has not been established and that remains to be seen whether or not this is a question that is ripe for decision at this point. Now, I could craft a very detailed and fleshed out jury instruction related to the issue of self-defense that is legally accurate. That does not mean at this point that warrants giving that instruction to the jury. I don't anticipate that there will be such an instruction in this case because simply speaking, the facts don't reflect that, the necessity of that instruction. So at this point, Your Honor, I mean, there's no assertion by Ms. Miller that she's relying on her subjective moral code in any day in question. Furthermore, the only report that we have at our disposal is one which relies only on legal wrongfulness and says without question that Ms. Miller was not appreciative of the legal wrongfulness of her conduct on the day in question. So the state certainly has the opportunity to re-raise this issue as this case proceeds up until the point where this jury receives the charge. But at this point, I think the court must ask itself, what is the rationale by which, from a jury perspective, this jury instruction is given? Because we certainly maintain that at this point, it would be inappropriate for a forensic examiner to receive this additional legal analysis, given the arguments we've raised previously that were since withdrawn, just on formality points. But as we sort of argued previously, these forensic examiners rely on ORC, and ORC alone, typically when they're doing this, they understand what the legal standards are at play, and to then give them more information, I think asks them to sort of umpire these legal disagreements by the parties, which is really not in their wheelhouse to do. And so we would agree, yes, on the general definition of what is and is not sanity under Ohio law. I would note that while there is some disagreement, as the prosecutor indicates, between the 12th district and some of the other districts, what remains true is that there is, in all but that 12th district, room for an objective moral inquiry when you're talking about insanity. And I do think that to sort of raise that issue when stated by the facts of the case would mislead the jury to the point where it might insinuate, based upon how this proposed instruction is written, that any time that a defendant raises a sort of deific decree or hearkens to some sort of conversation with this perceived higher power, that automatically disqualifies finding of sanity, which isn't Ohio law. And I'm not insinuating that's what Mr. Stiers is saying is Ohio law, but that is the risk that is run. And in our experience, there certainly is a risk when a jury is over-instructed. When under OJI, they're given sufficient instruction as to whether or not sanity can be found. And when you over-instruct that jury, you leave room for error, wiggle room, gray area, where they might be led astray. So, Your Honor, based upon that, we would rest on our motion and our objection. At this juncture, there is really no justification to give this instruction. It's an issue that can certainly be raised at a later date once this evidence has been fleshed out. But at this juncture, we would submit that it's not appropriate.
Brian, I know I said you the opportunity for rebuttal, and I'll allow for that. After I've heard from both of you, I do have just maybe one inquiry, and that is, we're talking about jury instruction, and that I can easily wrap my head around as to what that is, the fact that we need that, and then I would provide that to the jury. The part that I'm a little bit just confused about is because I guess I've never, that I can ever think of, ever having made some type of preliminary ruling that would in any way have guided the work of an expert, particularly in a question of competency or sanity. And I'm not saying it can't be done. I guess I'm just a little bit confused as to how will this ruling somehow impact the work of experts. I'm not saying it can be done. I've just never done that. That's all.
As you review this matter, Your Honor, I would refer you to my memorandum in opposition to the defendant's motion to exclude the sanity evaluation. Now, I know we've already settled that issue, but if you look at footnote 1, cites to the precise revised code, namely 2945.371 H and G, that sets forth in Ohio a forensic examiner's duty when they're evaluating sanity and competency, but sanity in this event. And it makes it clear that the forensic examiner's job is twofold. It is to draw a conclusion from fact-finding and then to apply that fact-finding to the law as it relates to sanity. Okay? So only when you have forensic psychologists testifying in court on issues of competency or sanity do you have this phenomenon where an expert needs to know the court's view of the law, if there's any dispute, as they do their work. It said that the forensic examiners should not be put in a position to umpire the legal disputes or disagreements of the parties. That's true. It's the court's obligation to do that. And if the court can do that before the work is done, then we're not going to be in a situation where fact-finding has been done and that has been applied to an inappropriate legal standard, compromising the conclusion. I think we need a process that is as efficacious as possible, and it's very rare that even in the context of insanity evaluations, which this court has overseen hundreds of times, it's very rare that there is a legal dispute, and it's very rare that there is a deific decree in a case. But it's this deific decree, this claimed deific decree, that requires the definition of wrongfulness to be fleshed out. So it was also said that there are no facts, I didn't write it down, but there are no facts before this court justifying this at this point. I would point the court to the hearing that we had, the relatively long bail hearing that we had, where a lot of the facts did indeed come into evidence. And so it's, really undisputed, I believe, that Ruth Miller immediately claimed to bystanders and then first responders that she threw her son into the lake, and that she did that because she believed, she was compelled by a feeling that God wanted her to do that. That's undisputed. So we know where this is going. We've already had one forensic examiner's report offered to the court that has spelled that out. And I would also point the court to that hearing and the evidence adduced at that hearing that suggested that shortly after she was confronted by the rangers who were first responders in Ranger Anderson's testimony, he indicated that she took off in a dead sprint and was lost. And that happens to be on the timeline for, I've been saying 30 minutes, that's very conservative. It's upward to 45 minutes. And that she's found lying face down quietly in high grass by the Welcome Center, almost a mile away from where she initially fled. And when she is found, almost 45 minutes later, she immediately says to the rangers, and this is on body cam and the court saw this, I threw him into the lake, I gave him to God, and people are going to tell me I'm crazy, but he is real and he loves you. People are going to tell me I'm crazy. So you not only have, and I'm sure the interpretation of these facts will be argued, okay? But a fair interpretation might be that she fled because she perceived that this was legally wrong, or at least wrong according to an objective moral standard. And that her claims that she felt that God was talking to her was in her head only, and that was subjective. And it's important that these forensic examiners and that later the jury know that we have a standard that we need to use when we assess wrongfulness, and subjective moral wrongfulness is not part of that. So, is that responsive to your question?
It does.
Okay.
Is there any further rebuttal that you wish to make?
Only I would argue that our instruction is a very concise statement of the law. It's 2 sentences. Our additional instruction that we're requesting is 2 sentences, and it encompasses both the 2 categories that should apply, and it specifically indicates the rejection of the 3rd category that should not. That would not be over-instructing the jury. Juries need to know, forensic examiners need to know clear, preferably concise, and accurate law that they need to apply to a situation, and this is all of that. It's clear, it's concise, and we agree it's correct.
Okay. Thank you. I'm interested in knowing, even though I said I was going to give the state a rebuttal, I'm interested in knowing if there is any response directed to Attorney Trott. My inquiry as to instruction given to an expert in this case, as I had said that I found it was a little unusual. I don't think, I'm not saying it's not going to happen or it couldn't happen, but I do find it unusual that there would be that need for the instruction at this stage. The state has articulated its position as to why. I'd be curious to know the defense's position.
Certainly, Your Honor. I would agree with the court's instinct. I mean, it certainly struck us as unusual or irregular. I think that's because it is. That's what prompted us to file our initial objection to that letter and the motion to exclude the report. And we also posed this question to our own our own case evaluator, Dr. Hatters-Friedman. We also posed it to the head of the Summit County Forensic Clinic that deals with the Summit County Court of Common Pleas, both of whom had never received such a request before, had never received a packet from a prosecutor, from another party, which seeks to sort of clarify an element of law, which they deem to be worthy of clarification. So I think the court's correct to sort of look at this with some I don't want to say confusion or suspicion, but just wanting to know why this would be relevant or needed. And so, I mean, for reasons that we've already raised, we would submit that it is not needed. Court evaluators across the state reach these conclusions, analyze these cases without the benefit of such extra analysis every day in every case that they confront. And so nothing about this case, while I would agree that the decree is, it's somewhat nuanced, it's irregular, it's not that common, I don't think anything about this case makes that general proposition any less true, that these professionals know how to do their job without the benefit of all this extra fluff. And they do it on a routine basis. And it's the same for juries, Your Honor. I mean, juries reach verdicts on sanity cases all the time across the state of Ohio without an instruction like this. This is a widely recognized area of the law, and I agree that it's nuanced. And that's exactly why you run a risk with a jury if you over-instruct them. Obviously, this is something that we're tangling with, and it's an element of the law which is, I would submit, somewhat unclear, and that's evidenced by I would agree with the thorough briefing that we've done on this issue.
Well,
And,
let me ask you this.
sure.
I think that the state would say, they would agree that it's unusual in that, I think their opinion is, why not give guidance to forensic examiner? Why not be more specific when dealing with a jury? Can you tell me, while I'm considering this, what would be the harm in essentially doing it slightly different, doing it preemptively, giving this instruction now as opposed to waiting and potentially giving it later? What would be the harm?
Well, Your Honor, I think as can be gleaned from the authority as delineated in these motions, it's somewhat of an open question. I mean, the courts come down somewhat differently. Defendants in Ohio have a right to be treated, equally in cases like this, and I do think there is a risk if we're sort of putting it on the shoulders of parties and jurists to give these instructions, that one defendant in one district might be treated differently than another. Now, in terms of whether or not and the same goes for a forensic examiner. Sanity is sanity, no matter what district you're in, and I think this issue is ripe for Supreme Court clarification at some point, whether or not there's enough case law right now to actually manifest to a split. I think there is, but it's not extremely stark. The risk is that a jury or a forensic examiner hears this standard and they go off on a tangent that isn't necessarily supported by Ohio law. That's the risk you run when you give so much instruction. Correct, but when you over-instruct. So that's the harm. And is there a world in which this evidence develops in such a way, for instance, if the state's evaluator or a different evaluator comes forward and says that Ms. Miller was acting on the subjective moral wrongfulness standard, and then facts come from the witness stand that say, yeah, we also believe that there's facts here that submit that she understood the legal wrongfulness or the subjective moral wrongfulness, then yeah, there might be a world in which the state's jury instruction is appropriate. The primary argument we're putting forward today, Your Honor, is that is not today. And ultimately, the court's only going to give one set of instructions. So I don't believe there's any harm in waiting, because if that evidentiary record was flushed out in such a way, then the jury hears it. And if not, they don't.
Thank you. I believe we covered all of the topics at this point in time. But just because we've got everybody here, Brian, aside from, again, anything further, not so much rehashing any of these arguments, anything else would need to be discussed while we have all the attorneys and Ms. Miller here.
The only reply I would make, limited to what Mr. Trott just argued, is that the suggestion it is an open question, I think, would suggest that the court should make a ruling on it. The fact that we agree that it's an accurate statement of law should resolve any open question that may be.
Examinations, though, are not being held up by this. It sounds as if everyone's moving forward and we're still on pace to be having that trial in March, correct?
We're planning on it. Yeah.
All right, I see that the state had an examiner in the Cincinnati area.
That's correct.
And we signed that order, right, and she's able to get that taken care of. I just wanted to make sure that we have everybody here, that we didn't have any outstanding issues that need to be addressed. From the defense standpoint, I don't know, Luke, is anything else, again, even unrelated to this particular issue that you need the court's attention today?
Not at this time, Your Honor. Thank you.
Then, Ms. Miller, as I said before, I'm not going to make a decision from the bench. I'm going to make a decision now, and I'm going to make the decision in this case. I believe there will be a decision from the court by the end of the day on Friday. One way or the other, I'll make a decision in this case. And that way, people can plan and move on. So if there's nothing further, we are adjourned.
Thank you. Thank you, Judge.
isn't anything else, right?
Yeah.